Hi, welcome to the 56th session on IBC, specifically covering the liquidation aspects. Today we are going to understand and go through few case studies which are all about companies that are undergoing liquidation presently. So we are going to see various forms, various public announcements made by these companies and also try to analyze how the scenario has changed in these cases. But before I take you to those aspects and tell you clearly about case studies, I want to tell you some few basic things about IBC and how it works when it comes to practical world. Basically, why will a company borrow money from different kinds of creditors? There are two kinds of creditors as we see right now. Basically, it is either financial creditor or a operational creditor. So operational creditor is somebody who's giving services to the company or giving products to the company to keep its business active. Whereas financial creditor is somebody who's lending directly money to the corporate debtor. Why is it borrowing these debts? It is borrowing these debts simply to carry on its business activities. While the lenders are believing that it is going to borrow for its business activities, they lend the monies. Borrowers, in actual sense, may not use this money truly to carry on business. That is where the whole problem of NPA or insolvency or avoidance transactions will come. Why? Because the funds that have been allocated or disbursed to the corporate debtor by the financial creditors, assuming that they are used for the business purposes, are being diverted by the corporate debtor to their personal accounts. It can be personal accounts, it can be for any other project, or it can be any other reason. But the funds that have been received from the lenders are not being deployed in the business in which they should have. These funds have been utilized or are being utilized in some other way, in some other sense, and causing a severe harm to the company and to the lender in terms of financial losses. So, this being the scenario, we need to personally observe and understand, analyze as to where the money has gone. The money that is borrowed by the corporate debtor for the purpose of business, where is it exactly gone? Is it a genuine business loss because of pest factors? We say political, economical, sociological and technological factors which are out of the control of the corporate debtor, or is there any deliberate ploy played by the corporate debtor in actually diverting the funds elsewhere? This is the first study that we all have to do while we are talking about IBC, NPS, etc. Also, one more thing that is important is most of the times the banks or financial institutions or lenders, whenever there is a failure on corporate debtor in repaying the money to the bankers, financial institutions, they will not instantly initiate a case under IBC. So what they do is they might wait patiently and they might give a notice to the corporate debtor that boss, your repayment schedule is not really up to mark, you're not paying debts on time, and therefore we might have to report you as a NPA. So after repeated such failures, then the banks might call such corporate debtor as a stressed asset. And there are categories of stressed assets which we've learned in the past. Now, after they categorize them as stressed asset, they call it NPAs. Only when they are NPAs, the bankers will initiate a case of IBC against such borrowers. Until then, they may not initiate. It is in their interest, that is bankers' own interest, to wait and recover the money in full rather than initiate an action of IBC. So these are a couple of things that we must keep it in mind, and also going forward we need to understand practically how, as a liquidator or as a resolution professional, public announcements are made, what kind of information is gathered, how they are used by the resolution professional or liquidator. So with this introduction, I'll take you to first case law of today, which is Vantage Machine Tools Private Limited. To tell you briefly about Vantage Machine Tools Private Limited, it is a company which is incorporated in Newsweed in Vijayawada, which is Andhra Pradesh. The company was supposed to manufacture machine tools in the same place, and it started with an authorized capital of about 10 crores and a paid up capital of about 8.06 crores. So why are we giving you these details? These details are important to understand whether this is a big company or a small company. So what do you think? This is a big company or a small company? See, as far as the Act is concerned, small companies are those, Companies Act 2013 is concerned. Small companies are those where the paid up capital is less than 4 crores and their turnover is approximately 40 crores. If the figures are less than this, such company can be called as a small company, and the figures are more than that, such companies can be called as big companies as far as Companies Act is concerned. But generally speaking, a 8 crore capital is a small company in terms of business sense. Large companies are those which have 500 crore capital, 1000 crore capital, and have turnovers of thousands of crores, right? But all those companies where the paid up capital is less than 100 crore, in our sense we can always call them small companies. Why am I saying that? There's a logic. Now look at the next line, where the company was into manufacture of machinery for mining, quarrying and construction. So with these machineries that are produced by this company, its customers might excavate earth and get into quarrying business, right? So with this business as a primary objective of the company, it borrowed funds from different bankers. One thing that you must ask, if you're not already aware of the fact, is that why will they borrow different funds or amount of funds from different bankers? Let's try and understand that every banker has a simple principle. The principle is that the entire loan exposure, suppose if I require about 1000 crores, and if one banker lends me 1000 crores, that banker is taking an enormous risk. Because if my business is not doing well, one banker loses 1000 crores. Hence, what they do is, in this kind of scenarios, they only take partial exposures. They will say that, I am going to lend you only certain percentage of your requirement, and the rest of the percentages you will have to tie up with different banks. So we as a borrower might approach different bankers and borrow different sums of money. On the other hand, sometimes the bankers themselves will form a consortium and will mutually decide who is going to lend how much, and collectively they will lend the required sum of money to the borrower. In this case, if you see, the overall borrowings were about 200 crores. Now, when you borrow this money with an objective of making machinery, what do you do with this money? Basically, what the company should do with that money is ideally install equipments, plant machinery in its own premises to actually produce that kind of machinery which it said, and also spend this money for payment of salaries, for working capital usage, for buying of raw materials, or whatever are the relevant expenses for its business and active running of the business. Instead, these companies might at times use the funds for different reasons. I'm not commenting, or I'm not saying that in this case it happened, but I'm just saying that a resolution professional or a liquidator who is appointed to take care of the process should first think like an inspector or an investigator who is actually coming with a negative mind. The mindset is simple that if you have borrowed 200 crore from the bankers, if you have not returned this money, the probability is that you have lost that money in the business, or maybe you have diverted this money elsewhere. So, as a resolution professional or liquidator, it is my primary job to actually examine this and come to a conclusion for myself. Let's go to next slide and see. So, this company, after borrowing so much money from different bankers, had eventually become insolvent. The question is, what is insolvency? If you recall all the sessions that we had on IBC, insolvency is nothing but a situation where a corporate debtor which has borrowed funds from different financial institutions and banks or creditors, including operational creditors, is not able to service that debt or repay that debt on time. In that scenario, it's called as insolvency or an NPA. So one of the financial institutions or creditors may actually file a petition with the NCLT and seek CIRP. This is what we have learned. Now, after the case has been initiated, either by an operational creditor or a financial creditor, the total claims made by the creditors were about 77 crores 9,44,300. So this figure is bigger or smaller? Okay, think of that. Claims. 77 crores is small claim or big claim? Currently, I am handling a personal insolvency resolution process where a personal guarantor who stood as guarantee to a private company is now under insolvency resolution because the company could not repay the entire loan, and then the lenders have pressed a case against the personal guarantor to pay the money. Now, while we are doing the PIRP for him, when we invited claims, unbelievable amount of claims were made. It is about 3,000 crores, a whopping amount of claim has been made by various creditors. Now, when you compare those claims of thousands of crores versus a 77 crore, this looks a reasonable size of claim, but however 77 crore on any day is not a small amount of money. Let's realize that. So the total amount of claims made by creditors was about 77 crores, 9 lakhs. And total amount of claims accepted was about 67 crores. So I would say about roughly 12 to 13% of the total amount claimed has been rejected for whatever reason, but however, good news is that substantial portion of the claim has been accepted by resolution professional for payment. Now, what happened then? See, what you need to understand is once a resolution professional is appointed, he makes a public announcement, he gets a claim, he verifies the claim, he admits the claim. Until then, it is not a big deal. It is a regular process. But the success of the CIRP will depend on whether you are able to sell the assets at such money to pay these debts. That's the real challenge for a resolution professional. Now, though he has admitted claims for a 67 crore 31 lakhs, let's see how much could he repay and how was his resolution plan. To name a few creditors, there were creditors like Canara Bank, which is a financial creditor, Mega Engineering and Infrastructures Limited, which is again a financial creditor. Then there's a Vantage Spinners Private Limited, which is a financial creditor, apart from the other banks. Also, there are financial creditors like P. Mohana Murali Krishna, Dhana Lakshmi Rao, Quality Steels and Wire Products, Some of them are operational creditors, as you see OC is written here. Some of them are financial creditors. But finally, these are some of the creditors who claimed a sum of about 73 crores. Now, list of claims were made by OC, FC, secured creditors annexed below. So let's see how much claims they made. In the first one, we are trying to understand the details of the operational creditors here. In the details of operational creditors, we can see the details of claim, right? Date of receipt, amount of claim. Then here, details of claims submitted as to when did they submit and how much was the claim that they made. And here you can see whether it's a related party or whether it is not, and percentage of voting share in COC. All those details are mentioned in Annex 3. Now, amount of contingent claim, that means where we are not certain that the claim is definite, it is called as a contingent claim. It is dependent on certain events. Now, amount of unsecured or amount of any mutual dues that may be set off. You can see here that as a resolution professional, when a claim is received, what kind of details you should gather to actually understand the claim and to process the claim. So we are trying to say that you should always have the date of the transaction, when the transaction happened, whether it is lending or an operational creditors transaction, and when was that submitted with proof, and how much is the amount of claim, and actually what is the percentage share that is likely to be given in the COC to them in terms of voting power. Then also, if there are any contingent claims, after that, can there be any amount set off against such claimant by the company? So set off would mean that the claimant owes some money to the company and company also owes some money to the claimant. So here the claimant is coming and saying that I need to get some money from the company. At the same time, resolution professional is also checking whether company should get some money from the claimant. So then he can mutually set off these claims and only give the balance to the claimant if required, or receive the balance from the claimant if required. So these are some of the fields that are created for the better understanding of the resolution professional as to what are the financial implications on the CIRP, right? So this is one form that is talking about operational creditors and their details. Let's go forward to understand other things also. Now here in this slide you can see we are now looking at unsecured financial creditors. See, financial creditors are two types, specifically financial creditors. This will not apply to operational creditor. Financial creditor who lent money can be either a secured creditor or an unsecured creditor. What do you mean by a secured creditor? Secured creditor is somebody who gets security on the assets of the company by way of a mortgage or a lien or a hypothecation. Once those assets are under your charge, then you're called as a secured creditor. But whereas unsecured creditor is somebody who doesn't have any such cover, who doesn't have any such protection, and is absolutely open for exposure. This classification applies exactly very well for a financial creditor who can be termed as a secured creditor or an unsecured creditor. So these are the details about the secured creditor. Let's look at what details we have. We will look at date of receipt of the claim, amount claimed by the person. So this is details of claim received. Now this is details of claim admitted. So we are saying amount of claim admitted, nature of the claim, amount covered by guarantee, how much was the original amount, and then how much is the claim now. Whether the party is a related party, percentage of voting share in the COC, as we said before, amount of contingent liability, and after that amount of mutual set off that is possible. After that, we are saying it goes to the total verification and then we confirm whether it is payable or not payable. This is the entire statement of affairs as far as unsecured financial creditors are concerned for the resolution professional. Now we go to third one, which is a list of financial creditors who are secured. Now in case of secured financial creditors, let's see what is the information that we have. We will have name of the creditor, we will have date of receipt, we have amount claimed, then again amount of claim admitted, nature of the claim, amount covered by security interest. Because we are talking about a secured financial creditor, we should also know how much of this loan is secured by way of a security given to him. Amount covered by guarantee is how much? As a personal guarantor, was there any person who is giving you guarantee to repay your loan? Then whether the such party is related party, what is the percentage voting share in the COC? After that, contingent liabilities if any, and then mutual set off of the funds if possible are all generated. So now what we are trying to say is, see, the creditors are different types. Number one is a financial creditor in which we have unsecured, secured creditor. After that we have operational creditors, then we have workmen and the employees, and after that we have other categories who are not covered in these, right? So for each category, the RP should receive this kind of an information in a systematic format so that we can actually process this list of creditors. Now, until now what we've understood is only about claims made, claims admitted, claims rejected, etc. But after admitting the claim, as a resolution professional, your duty is to ensure that you get enough money from the CIRP to pay to these claimants according to the admitted ratio. But however, in practical life, what happens is it may not always be possible to get that. Heard about haircuts in the resolution process. If you see a case like Videocon, maybe one of the highest haircuts had happened there. And there are lots of other cases also. Ideally, the bankers, financial institutions or the lenders are ready to lose up to 20 to 25%. This is an average loss. But in some cases, we have seen that the creditors or the lenders have lost 95% of the amount that they lend, and they could only recover 4 to 5% of the amount. These are miserable cases but possible. So in this case, what happened is our curiosity, right? So did they recover the full money or not? Let's try to understand it first. Because see, we are currently talking about liquidation and I am showing you a case of CIRP, right? Why am I showing you a case of CIRP? Always remember, whenever there is an insolvency issue, firstly we attempt a insolvency resolution process which will revive the company and let it run as usual. But when CIRP fails, only then there will be a liquidation, right? So first question is, did you attempt a CIRP? Was it successful or not successful? In our case, we are saying yes, CIRP was attempted. It failed due to unresolved disputes and disagreements regarding outstanding debts. So when I, as a proposed buyer of the new company, I approach this scenario, I will see that I have no fixed concrete amount of liability as of now. Everything is actually liquid state. So after I buy the company, when I look at the total liability of mine, the total liability might run to 1000 crores or 200 crores that I am not aware, because today we don't have a settled list of creditors and settled amount of credits. So therefore, most of the buyers will back off. They will not buy this kind of a company. Either in the form of an asset or as a form of a company. So therefore, when the CIRP is failing, it has to obviously go to liquidation. The important question is also as to who is the RP at that time. RP was Mr. Immaneni Ishwar Rao. And because the CIRP failed, the RP naturally would recommend liquidation to the adjudicating authority, and adjudicating authority had passed an order for liquidation on 20th December 2024. Friends, 20th December 2024 is very recent. So I am just trying to tell you this case because it's just few months ago. Now, if the liquidation commencement date LCD is the common terminology that we use is 20th December 2024. When should the liquidation get completed? Liquidation should naturally get completed by 19th of December 2025. Hence, currently the scenario can be that the liquidation is still in process. Let's try to understand what's happening at this point of time. Name of the liquidator is very important because the liquidation order is already passed on 20th December 2024. The Honorable National Company Law Tribunal had also appointed a liquidator by name Kalva Kolanu Murli Krishna Prasad. And this man made a public announcement within what time? We remember the timelines that we have studied. The public announcement under liquidation should come within 5 days. So he made a public announcement on 24th December 2024. And public announcement was like this. Let's try to understand what information do you give to the public when you are actually trying to give a public announcement. This public announcement, remember, is not for the sale of the assets. This public announcement is simply for receiving the claims from various creditors. So what is the information that we give to the creditors and how? This is called as Form B, Public Announcement, Regulation 12 of IBBI Liquidation Process Regulations 2016. And it says that for the attention of stakeholders of Messrs. Vantage Machine Tools Private Limited. And now we have the particulars, very important. What particulars do we have? Number one, name, date of incorporation, authority under which corporate debtor is incorporated. Then corporate identification number. This is important. So this is the identification number of the corporate. Then address of the registered office is given here, date of closure of insolvency resolution process. See, commencement of liquidation is automatically conclusion of the insolvency resolution process. And hence the moment liquidation is commenced here, insolvency is also concluded. Name and registration number of the insolvency professional acting as liquidator, because public will need his information from time to time as to who he is, what is his address and what kind of a human being he is. All these details are placed on IBBI's website, and any person who is interested may actually go to IBBI website and find out about these resolution professionals or liquidators, and you will get a fair amount of information. Last one is address and email of the liquidator as registered with the board. This is the same man, the liquidator. Address and email to be used for correspondence with liquidator. And then lastly, it says last date for submission is 23/1/2025, and it further says that notice is hereby given that the National Company Law Tribunal, Amravati Bench, has ordered the commencement of liquidation of the Vantage Machine Tools Private Limited, wide order dated so and so, order copy uploaded on 21st/12/2024. Now he says the stakeholders of Messrs. Vantage Machine Tools Private Limited are hereby called upon to submit their claims within proof on or before 23/1/2025. So before 23rd of January 2024, the claim should have been made by various parties, which is 30 days from the date of announcement. Also, it writes that financial creditors shall submit their claim with proof by electronic means only. All other creditors may submit the claims with proof in person, may, by post or electronic means. The submission of false or misled or misleading proof of claims shall attract legal provisions. This is how public announcement is made by the resolution professional who is called as the liquidator. Now, pursuant to this announcement by the liquidator, claims will be made by the parties, and after claims are being made by the parties, the claims are verified, and once the claims are verified, claims are admitted and informed to the respective persons as to whether the claim is admitted or rejected. Now, once that's done, a stakeholders consultation committee is formed, and then the matters are put forth before the stakeholders consultation committee, while the liquidator will keep on negotiating a liquidation plan and also will try to arrange a valuation. At the same time, will also try to arrange a public auction so that the assets of the company will get a better price. So this is one case law that we studied about one company. We will also look at other cases to understand what went wrong or right and how these guys are handling their liquidation processes. Thank you.